Good morning. We want to welcome each of you to the August 14 meeting of the Tennessee State Board of Funeral Directors and Embalmers. I want to ask Miss Lisa Mosby, if you would, to call our roll.
Wayne Hinkle.
Here.
Tony Highsmith.
Here.
Clark McKinney.
Here.
W.T. Patterson.
Here.
Jane Gray Sile. Here. Robert Starkey.
Here.
Anita Taylor. Mr. President, everybody is here except for Ms. Taylor.
All right. Chair will adopt a motion, entertain.
I move that we accept the agenda that has been presented, Mr. President.
It all didn't come out, but you know what I meant.
Second.
Have a motion by Mr. Highsmith and a second by Mr. Hinkle to adopt our agenda for today's meeting. All those in favor say aye.
Aye.
Opposed? Motion carried. I want to give you just a few minutes to review the minutes from the July 10 board meeting. Let the record reflect that Ms. Taylor has arrived, fashionably late.
I drove today. I hope I'm in the right spot.
We're reviewing the minutes.
Let's get out of the agenda. Hey, there you go.
I was punching on the wrong side. We'll get this worked out.
Click and then library takes us back. Got how to do it. I forget where it is again.
Chair will entertain a motion to adopt the minutes of the July 10 meeting.
Make a motion.
We have a motion by Mr. Starkey to adopt the minutes of July 10.
Second.
Have a second by Ms. Sile. All those in favor say aye.
Aye.
Opposed? Motion carried. Next item on the agenda is our legal report. Mr. Benton McDonough is our Assistant General Counsel.
Thank you, Mr. President.
Sir, go right on.
First complaint is complaint number 2012004821. Number 2 is 2012004822. And number 3 is case number 2012004823. The complainant states that her sister's funeral was held at the respondent funeral establishment, and that she states that she had great respect for the individuals who worked there until Friday, February 3rd, 2012. On this day, the complainant states that respondents number 1 and 3 informed her that, number 1 and number 3 are the same individual. Respondent number 1 and number 3 told her that he had something he couldn't share with her over the phone, and that she later had a conversation with the respondent regarding a sexual dream he had about her. The complainant states that the respondent told her he could provide her a discount for her sister's headstone, and he wished that she would remove her shirt or her pants so that he knows that she won't tell anyone. The complainant states that she left the conversation feeling disrespected, and she reported it to the respondent's supervisor the following Monday. Later that night, the complainant states that the respondent's wife sent a text to the complainant's other sister apologizing for what her husband had done, and her father called the funeral home to speak with the supervisor, but he wasn't in at the time. 5 minutes later, the complainant states that the respondent's wife called the complainant's brother and told him to quit calling. The complainant called to speak to the manager again, and he said it was best for them to purchase the headstone somewhere else, and told her to quit calling, and said that she was yelling and hung up on him. The complainant called back and reached the respondent, who asked her what she wanted from him, and said, "Fine, I apologize," and I'll leave it at that. The complainant states that she was sexually harassed, and she feels like the respondent tried to use her sister's headstone to get sex from her. In response, respondents 1 and 3, the complainant is the former sister-in-law of the respondent's wife. The respondent states that his wife's ex-husband and his family have continually harassed, threatened, stolen from, and lied to the respondent and his family. The respondent states that they received no financial assistance or child support from his wife's ex-husband whatsoever. The respondent and his wife have worked to keep her ex-husband from going to jail for failing to pay child support. However, the court instructed her ex-husband during the previous proceedings that he would be taken into custody if this issue came up again. Respondent believes that this complaint was filed as revenge for the ex-husband possibly going to jail. The respondent states that he did not sexually harass the complainant and he has no physical attraction to her whatsoever. The respondent states that this family has continued to treat him poorly despite his involvement in the funeral services for the complainant's sister, and also his involvement which came at the request of the complainant's family. The respondent states that he did in fact meet with the complainant on the day in question, but it was in a public location to discuss the cost of the headstone. Following this conversation, the complainant informed the respondent that she could not stand his current wife. On the following Monday, February 6, 2012, the respondent answered a call from the complainant regarding their conversation, and the respondent apologized for anything he did to offend the complainant, and even offered to apologize to her husband and other family members in person. Respondent number 2 states that he has known the employee, respondent number 1 and number 3, since 1988, and he is a trusted employee and friend. Respondent spoke to his employee, who flatly denied the allegations from the complainant. The establishment conducted the services for the complainant's sister, and the family personally requested that the employee respondent conduct the services, despite the fact that the complainant's brother is the ex-husband to the respondent's wife. The respondent and his wife have custody of the ex-husband's 3 sons, and they provide this care without support from the ex-husband. Members of the complainant's family have threatened to kill the respondent in the past, and they have given him many problems. The complainant spoke to respondent number 2 on February 6th, and he apologized and explained that he would get to the bottom of the situation. The complainant called back the very next day, very combative and screaming as her kids screamed in the background. The respondent stated that he would speak to her, but only if she could calm down and quit screaming. Then the respondent hung up on her. The complainant called back and spoke to the employee respondent. The employee stated that he confronted the allegations at the time and that the complainant would not give him a reason for the accusations, and he apologized for whatever he did to upset her. We found a history of no prior complaints for respondents number 1 and number 3, and 3 prior closed complaints not related for respondent number 2. We have since received a letter from the complainant asking that the charges against the respondents be dismissed, and we are also recommending that the charges against respondent number 1, number 2, and number 3 be dismissed as well.
I'll move we accept the legal counsel's recommendation.
Second.
We have a motion by Ms. Sowell to accept council's recommendation and a second by Ms. Taylor. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 4 is case 2012007161. On March 15, 2012, the complainant provided the board with one advertisement published by the respondent. The advertisement appeared in the Sunday, March 11, 2012 edition of the local newspaper. The advertisement lists a simple cremation service, direct cremation with container, for only $750. The respondent's general price list does not list this package as advertised, nor are the charges itemized in the explanation of the package. In response, the respondent points out that the advertisement states that the package was based upon the general price list effective July 25, 2011. However, the complainant used the general price list from April of 2011. Next, the respondent states that the direct cremation is one of 4 minimal services required to be listed on the general price list and is not considered a package under the funeral rule, nor does it have to be presented as a package on the general price list. Furthermore, the funeral rule requires a range of prices for a direct cremation and one price for a direct cremation with family providing the container and one price for a direct cremation with alternative container. Respondent states that the funeral rule requires items included in the minimal service be listed, but the cost of each item does not have to be itemized. For the state to call a direct cremation a package and require itemization goes against the general application of the rule. Also, to say direct cremation is a minimal service for the general price list and contract purposes, and then call it a package for advertising purposes is arbitrary and confusing. We found a history of 6 closed complaints, and one open complaint, none of those related to this matter, and we're recommending a letter of warning in this case.
Motion to accept council's recommendation.
Second.
We have a motion by Mr. Hinkle to accept council's recommendation, seconded by Mr. Patterson. Any further questions or discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 5 is case 2012007171. On March 15, 2012, the complainant provided the board with one advertisement published by the respondent. The advertisements appeared in the Sunday, March 11, 2012 edition of the local newspaper. The advertisement lists cremations starting at $892. The respondent's price list on their website does not list this package as advertised, nor are the charges itemized on the explanation of the package. The respondent states that the complaint is correct, that the cremation starting at $892 is not on their price list as a package. Respondent states that they first ran the advertisement on April 18, 2010 and failed to include what was included in the price. On Wednesday, April 21, 2010, the same complainants filed a complaint, and the respondent immediately corrected the error and have since run this advertisement an average of 3 times per week for the past 23 months. In regards to packages, the respondent states that they do not offer packages at their firm any longer, but they did leave the 3 packages on their website from the past. And the respondent states that their webmaster failed to click Do Not Show in order to remove the packages from their website. Finally, the respondent states that they have never placed their general price list on their website, but they did list their $892 direct cremation offer and what it represents and includes. We found a history of 5 closed complaints and 3 open complaints, 2 of those related, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
This recommendation has to do with the incorrect information that actually ran in the paper as stated there, I believe, in number 2, correct?
That's correct.
Move to accept council's recommendation.
Second.
We have a motion by Mr. Highsmith, seconded by Mr. Hinkle to accept council's recommendation. Have any further questions or discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 6 is case 2012007661. On March 19, 2012, a field representative conducted an inspection of the respondent establishment. The respondent applied for an establishment license and was not properly approved for licensure when the inspection took place. The field representative found a sign in place at the location announcing the grand opening. A sign on the door of the establishment published the name of the business as seen on the application for licensure. The establishment hours of operation were published on the door, and the establishment published a 1-800 number used to contact the establishment. In response, the respondent believes that they inadvertently violated state rules by having a temporary canvas banner tied on the building announcing the grand opening and the future hours of business. Respondent states that the field representative stated that these violations made it appear that this was a licensed entity open for business prior to the official licensing approval. Respondent concedes that the inadvertent premature advertising, posting of a temporary sign announcing grand opening, and posting name and prospective hours of operation amounts to a violation of the board rules prohibiting advertising prior to license approval. The respondent admits to these violations despite lack of fully staffed office. The office was still being assembled and equipped, not open for business, and no sales manager, staff, administrative staff, or sales representative had been hired. While the respondent admits violations, they disagree with the actions termed as willful or fraudulent attempt to misrepresent the status of the business to the public. They state that there was no harm brought to the citizens of Tennessee, and the signage was immediately covered on the door and taken off the building within 24 hours. The respondent operates in 14 states with similar rules, and despite warnings from the respondent's legal counsel, the company failed to adequately communicate to the crew in Tennessee regarding advertising and signage prior to official approval. We found no prior complaints against this establishment, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
I make a motion we accept.
We have a motion by Mr. Patterson to accept the council's recommendation,
Second.
and a second by Ms. Sowell. Any further questions, discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 7 is case 2012009131. Case number 8 is case 2012009132. Number 9 is case number 2012009133. This complaint was filed by a consumer on April 12, 2012. The complainant's husband was under hospice care, and the family had already pre-planned funeral services with the respondent's competitor, but the hospice social worker suggested that the complainant and her family go to see the respondents. The social worker provided a name of her friend and the respondent's phone number. The complainant states that they had already made a decision to go with the competitor and decided not to call the respondent. However, the social worker's friend called the complainant to ask that they consider using the respondent's services. The complainant was contacted numerous times by the respondents, and the respondents informed the complainant that the respondents could beat any price that the competitor would hit the complainant with numerous hidden fees. The complainant believes that it is improper for a hospice facility to push and try to alter a family's decision regarding the final arrangements of their terminally ill loved one. In response, respondents number 7, number 8, respondent is saddened that a family would be upset by his assistance in funeral planning. In early 2012, the respondent was contacted by the hospice company with the name of the family member and requested that he contact the family. The employee indicated that the family had no funeral plan and that they were collecting information to make their decision. The respondent states that the exact phrase was that they are simply shopping around looking for the best price. The respondent states that the family gave him permission for him to contact them. The respondent contacted the complainant that morning and believed that they had a very productive conversation about the wishes of the family for a simple cremation. Respondent states that he informed the complainant that some funeral establishments are not very forthcoming regarding all of the charges assessed as they relate to containers, urns, receptacles, permit fees, etc. The respondent ended the conversation with a scheduled appointment for later that afternoon, but the complainant failed to keep that appointment, and the respondent later contacted her, and she informed him that she had made arrangements with the respondent's competitor. The complainant's daughter knew the owner of the competitor, and the complainant stated that the family just felt more comfortable there. The respondent states that he informed the complainant that they made a good choice and that he would be available should she have further questions or concerns, ending the conversation on a positive tone. The complainant's husband passed away, and services were conducted on April 11, 2012, with the complaint being filed on April 12, 2012. And the respondent believes that the complainant would have contacted him or the board sooner had she been upset by the tone or acts of the respondents. The respondent states that he worked as co-owner with his competitor for 10 years, and that he states that many of the relationships that he has forged over the years with caregivers around the state occurred while he was employed by the competitor. The respondent believes that he did nothing improper. Respondent number 9 responds that their employee did receive permission to contact the complainant and set up an appointment following the complainant's appointment with the competitor. The complainant did not show up for the respondent's appointment and apologized to the respondent when the respondent called regarding the missed appointment for not giving the respondent an opportunity to serve the complainant, but the complainant stated that they felt very comfortable at the competitor's establishment. The respondent believes that 3 points are very important. First, that the complainant made the appointment because no funeral arrangements had been made at that time. The employee had the following day as a courtesy, since the complainant did not keep her scheduled appointment and was told that the complainant had finalized their arrangements with the competitor. And third, if 2 calls should be considered multiple calls, then they are guilty of that act. The respondent would like to address a few items that are critical in this complaint. The employee resigned his position with the competitor in August of 2011 and came to work for the respondent 1 month later. The employee cultivated relationships with the hospice caregivers while employed by the competitor, and also an employee of the competitor appears to have assisted in filling out the complaint form and notarized the document as well. As for history of complaints, we found no prior complaints for respondent number 7 or number 8. And we found 5 closed complaints, none related, and 4 open complaints, none related, for respondent number 9. And we are recommending dismissal of the case against respondents number 7, number 8, and number 9.
Motion to accept council's recommendation on all three.
We have a motion by Ms. Taylor to accept council's recommendation. Let me ask a question. Now, where did this complaint come from?
It was filed by the complaint, by the, I guess, the customer in this case.
Okay, a family
Family,
filed
yes.
a complaint. Now, and then where does hospice come in on this?
The family member of the complainant was in hospice care, and the employee for the hospice care center pointed them in the direction of the of one of their friends who happened to be the respondent number 7, number 8 in this case, as the family was looking, it appears, looking for the best deal for funeral services in this case.
But isn't this still solicitation of a dead human body?
I don't think it falls under solicitation. I mean,
What would it be?
there wasn't any, I mean, the hospice worker, I don't think, received any sort of payment or anything like that for this act. She recommended them to the family.
Has a complaint been filed with the hospice organization?
I'm not aware if one has or not.
The reason I'm asking these questions is, and some of the board members may be aware, may not be aware, but we have several hospice organizations that seem to have formed an alliance with some establishments. And, they're really on, to me, my opinion is they're kind of on thin ice. If we don't know what the relationship is with the establishment and the hospice. A licensed funeral director cannot solicit somebody when death is imminent, and we certainly do not want them to have an agent within hospice that's there, of course, when death is imminent, doing their bidding for them. So,
Is that not covered in the last legislative session about conflict of interest between funeral directors serving with hospice organizations, board of directors, things of that nature?
I think that did not come to pass.
It was.
The legislation didn't pass. There was a bill.
I don't think
it
was even introduced, but it was discussed.
It didn't pass for sure.
I know we have a motion on the floor, but I would be in favor of at least a letter of warning.
I don't think the funeral director should have ever contacted his family on the word of the hospice. It's unprofessional. It should have never happened. The family should have contacted him if they were interested.
And the complaint did come from the family. It would have been somewhat different if it had come from a competitor. Maybe. Do we have a second on Ms. Taylor's motion?
I'm going to second, but I'd like to ask her if she would amend it to include a letter of warning.
If you don't second it, then it's going to die. It will die for lack of a second, and then we'll start over again.
Okay.
If, depending on what
I'll
Ms. Taylor
withdraw
wants
my
to do.
second.
Okay.
So would I make a new motion?
All right, going once, going twice, no second, so the motion fails for lack of a second now. Let's see if we can start over.
I'd be in favor of a penalty, a letter of warning about unprofessional conduct. Make a motion that the respondent number 7, 7, 8, 9. Respondent number 7 who actually contacted the family. Is that correct?
That's correct.
Respondent number 9 is the establishment. And respondent number 8 being the embalmer, I assume is the same person as number 7.
That's correct.
So we just doing the establishment civil penalty and a letter of warning on the other two? Okay. Okay.
What was the penalty?
What
I
you
would
thinking?
recommend, I make a motion, we assess a civil penalty of $250 against respondent number 7, and a letter of warning to respondent number 9.
Second.
8 and 9.
I really don't see how 8 comes into play when he's the same person as 7, but I guess a penalty of $250 to be assessed against respondent 7 and 8, which is apparently the same person, and a letter of warning.
Are we talking about two separate civil penalties of
No,
two?
one civil penalty, $250, and a letter of warning to respondent number 9 regarding unprofessional conduct of an employee, licensed funeral director, contacting a family that is under hospice at the encouragement of the hospice personnel.
Did you get that?
Yes, I did.
Second.
All right, we have a motion by Mr. Highsmith to assess a civil penalty of $250 on numbers 7 and 8. That's just a total of $250. And then a letter of warning on respondent number 9, and that was seconded by Ms. Sowell. I have a question.
Authorization for hearing.
Yes.
Yes. Any further discussion? Questions? All those in favor say aye. Aye. Opposed? Motion carried.
Number 10 is case 2012010511. The decedent in this case was removed from a local hospital by a removal service. The complainant states that the facilities were unclean, that the respondent was unprofessional. Complainant states that a bloody sheet was haphazardly thrown over the body and that the decedent's feet were hanging off the end of the table. The complainant states that dried blood was in both ears and appeared in the ears, both ears on the day of the funeral. The complainant states that the parking attendant ran the complainant's car into the back of another car, and that the complainant states that she and her family have suffered mentally and physically from this experience. The decedent's husband was given an unsigned copy of the bill, and the family did not receive the casket they chose. Also, the family asked for a steel vault and received a concrete vault instead. Their complaint states that they were charged for a flower van and had no flowers to take to the graveside. In response, we received no response from the respondent in this case, and we found a history of 2 open complaints and 1 closed complaint, unrelated. And we're recommending a consent order with a $1,000 civil penalty plus a $250 penalty for no response, for a total civil penalty of $1,250 and authorization for a hearing.
Motion to accept council's recommendation.
We have a motion by Mr. Hinkle to accept council's recommendation.
Second.
We have multiple seconds. Second by Ms. Taylor. Any further discussion?
Just one item of question, and it's immaterial to what we're going to vote on, but how did this complainant get access to where this body was kept and witness these unprofessional acts when it should be in a locked facility that's not enterable by the public?
I think part of her information came from the individual who was providing services for makeup and hair for the decedent in this case, and so.
Thank you, Mr. President.
Okay. All those in favor say aye.
Aye.
Opposed? Motion carries.
Number 11 is case 2012011351. The complainant, a competing funeral establishment, states that the respondent, an interment company has been offering cremation services via their website. The complainant states that the website is misleading and deceptive, leading consumers to believe that they have a funeral establishment in various states and cities, when in fact they do not have a licensed facility and are not a licensed establishment in the state of Tennessee. The business model is the same throughout the United States. The website shows the respondent's name with funeral services provider listed below that, leading the public to believe that the respondent has an establishment. The respondent even has a cremation authorization document with the name of the respondent at the top. The website also advertises cremations for between $695 and $1,395, and the website lacks an address and only provides a phone number. We received no response from the respondent in this case, and we found no prior complaints, and we're recommending a consent order with a $1,000 civil penalty plus an additional $250 for no response, for a total civil penalty of $1,250 and authorization for a hearing.
The complainant states that the cremation company does not have a funeral establishment license in the state of Tennessee. Is that indeed correct?
That's correct.
Move to accept council's recommendation.
Second.
We have a motion by Mr. Highsmith to accept council's recommendation, seconded by Mr. Hinkle. Any further questions?
Question. Shouldn't a letter of warning be sent to these people about advertising or something? In other words, they're advertising as a funeral home, they're advertising, as far as to cease and exist.
Cease and desist.
If you would
Council,
like,
would that not be in the letter of warning or
in the consent order.
How they operating is they're not licensed.
no, I mean we can send a cease and desist order if you'd like us to do that as well, separate from the consent order.
Have they, to your knowledge, have they ever made application for an establishment license?
Not to my knowledge.
Then my motion is to accept council's recommendation with the addition of a letter of cease and desist be included as well.
Second.
Second.
Okay.
I assume that would have been
Okay.
standard procedure, but thank you, Mr. Bob.
That was motion by Mr. Highsmith, seconded by multiple seconds by Mr. Hinkle. I think I'd already done that. So we're ready to vote. All those in favor say aye. Aye. Oppose? Motion carried.
Number 12 is case 2012012-541. On March 26, 2012, a routine inspection was conducted at the respondent establishment. It was determined that the preparation room floor is in need of replacement and that the respondent failed to retain the following cremation authorization forms for Shirley Jones, Antino Spears, and Maurice Side. We found no response from the respondent, and we found a history of 2 closed complaints, none related to this case. And we're recommending a consent order with a $500 civil penalty plus an additional $250 for no response, for a total civil penalty of $750 and authorization for a hearing.
I make a motion that we accept the council's.
We have a motion by Mr. Patterson to accept council's recommendation,
Second.
second by Mr. Highsmith. Any further discussion, questions? All those in favor say aye.
Aye.
Oppose? Motion carried.
Number 13 is case 2012012-561, and number 14 is case 2012012-562. On February 13, 2012, a routine inspection was conducted at the respondent establishment. The funeral director's license expired on November 30th, 2011, and was not reinstated until December 16th of 2011. From December 1st through December 15th, 2011, the funeral director was involved in 5 cases as evidenced by her signature as the funeral director on the death certificates. These decedents included Aaron Todd, Mildred Smart, Geraldine Porter, Richard Hall, and Lois Travis. In response, respondent number 14 states that she renewed her license on the board's website on November 30th of 2011, and that the respondent states that she entered all the relevant information, including the credit card information for payment. The respondent states that after 2 weeks, when she did not receive her renewal card, she checked her credit card to see that no funds had ever been removed from her account. The respondent immediately called the board office and found that her renewal was never completed. The respondent completed the renewal process again and paid the $200 late fee and later received her renewal card. Found history of one closed complaint not related against respondent number 13 and no prior complaints against respondent number 14. And for respondent number 13, we're recommending a consent order with a $500 civil penalty and authorization for a hearing, and number 14, a consent order with a $500 civil penalty and authorization for a hearing.
And that's consistent with what we've done in the past.
Yes, yes
Okay.
it is.
All right.
It said the respondent immediately called the board and found that the renewal was never, does that mean was never received or never, it was started and wasn't completed, or?
Apparently the renewal process was not completed on her end of the transaction, and so.
In other words, you couldn't see in the board where she had tried to, or?
No.
Okay.
This wouldn't be the same case we had a month or two ago.
It is the same individual, but there was it's a different funeral establishment. It was actually the same case from same facts really from last month, but there was not a complaint open against her in that case, and it was only against the establishment in that case. So this is actually the first time that she's been a complainant under these facts. I mean, a respondent under these facts.
Move we accept council's recommendation regarding respondent number 13 and respondent number 14.
Second.
We have a motion by Mr. Highsmith to accept council's recommendation, seconded by Mr. Hinkle. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 15 is case 20120125771. On March 20th, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent has a manager of record. However, another employee has been signing documents as the managing funeral director. The board has not received any notification that the manager of record has changed. Also, one individual uses business cards that only use the title of owner, but the card does not indicate that the individual is not a licensed employee. And on the general price list, the low to high end range is inconsistent with the outer burial container price list. Also on the general price list, the immediate burial price is inconsistent on the general price list and the casket price list. On the casket price list, under direct cremation, the 3 alternative containers being offered to the consumer must be added to the general price list. Also under general price list, direct cremation with alternative container, the price is inconsistent with the price on the casket price list. And then on the casket price list, 2 caskets, the 18 gauge gold and granite and the burnished silver. In the casket selection room being offered to the consumer, the price on the unit is inconsistent with the casket price list. Once again, we received no response from the respondent in this case, and we found a history of 6 closed complaints, 2 of those related, and we're recommending a consent order with a $750 civil penalty plus $250 for no response, for a total civil penalty of $1,000 and authorization for a hearing.
Motion to accept council's recommendation.
We have a motion by Mr. Hinkle to accept council's recommendation,
Second.
second by Mr. Highsmith. Any further questions or discussion? All those in favor say aye.
Aye.
Opposed?
Motion carried.
Can I ask one question? I'm bad to go to sleep sometimes. Did we jump number 12? We didn't. We handled it.
Yeah.
Okay. Well,
Yeah.
I kept looking. I thought,
Yeah, we got it.
we handled it. Okay.
Yeah, we did.
That's good. Sorry about that.
It's all right.
I told you I've been known to sleep a little bit.
Number 16 is case 20120125881. On March 14th, 2012, a field representative conducted a routine inspection of the respondent establishment. The establishment hired a new manager on February 29th, 2012, but the respondent never notified the board of this change. As for the statement of funeral goods and services selected, three of them did not have the reason for embalming filled out. And as for the casket price list, there were 4 caskets: the 20-gauge Roman, the 18-gauge Antique Blue, the Cortland Oak, and the 18-gauge Amethyst. Could not be identified on the casket price list, but were shown in the casket selection room. In response, the respondent states that they were acquired by another firm and thought that the main office provided the notice of change of manager to the board. Respondent has addressed the need to provide the reason for embalming on all statements of funeral goods and services selected in the future. The respondent states that they were acquired by another firm and had a change in the manner in how they displayed and marked the caskets in the casket selection room, and the respondent mismarked 4 units and made the appropriate changes while the field representative was still present. We found a history of 2 prior closed complaints, one of those with similar violations, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Motion to accept.
We have a motion to accept council's recommendation by Ms. Taylor,
Second.
second by Mr. Patterson. Any further discussion? All those in favor say aye. Aye. Opposed? Motion carried.
Number 17 is case 2012-012611. On April 10th, 2012, a field representative conducted a routine inspection of the respondent establishment. The general price list did not have a telephone number as required by the funeral rule. The general price list, the casket price range on the general price list was incorrect when compared to the price of caskets on the casket price list. And also on the casket price list, the casket price list had no effective date as required by the FTC. Also, the respondent's preparation room floor is in need of replacement, and the respondent failed to provide a copy of the crematory license and latest inspection report for the crematory utilized by this establishment. The respondent conducted cremation arrangements for 3 deceased individuals without retaining a copy of the cremation authorization form. Those individuals are Mark Anderson, Shelley Sorrell, and Robert Way. In response, the respondent states that there was a typographical error on the general price list and that this has since been corrected. The casket price range on the general price list was incorrect when compared to the price of the caskets on the casket price list. So the respondent has corrected the casket price list and attached the proper documentation. As for the preparation room floor, the respondent states that the floor was repaired and photographs were attached in response. And the respondent states that they have retained a copy of the crematory license and latest inspection report of the crematory utilized by this establishment. We found a history of 6 closed complaints, and one of those was similar in facts to this case. And we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Make a motion, we accept council's recommendation.
Second.
We have a motion by Mr. Starkey and a second by Ms. Taylor to accept council's recommendation. Any further discussion? All those in favor say aye.
Aye.
Those opposed? Motion carried.
Number 18 is case 2012-012631. On February 29th, 2012, a routine inspection was performed at the respondent establishment. The respondent failed to provide a copy of the latest inspection report and license of the crematory utilized by this establishment. Also, on the general price list, immediate burial with casket selected from respondent funeral home range was incorrect when compared to prices of the caskets on the casket price list. Also, direct cremation with casket selected from our funeral home range was incorrect on the general price list when compared to prices of caskets on the casket price list. The traditional funeral service package price was incorrect on the general price list. And on the statement of funeral goods and services selected, respondent must provide a description of merchandise, casket, and outer burial container selected with the price of each item. Several of the statements of funeral goods and services selected did not provide a description of the merchandise selected as required by the FTC. And as for the outer burial container price list, the respondent's price of the Wilbert Monticello burial vault was listed on the outer burial container price list as $1,695, but the price of the sample offer for sale in the selection and arrangement office reflected a price of $1,875. We received no response from the respondent in this case, and we found a history of one closed complaint and one open complaint, and one of those being related to this case. And we are recommending a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750 and authorization for a hearing.
Move we accept council's recommendation.
Second.
We have a motion by Mr. Highsmith to accept council's recommendation and a second by Ms. Sowell. Any further discussion? All those in favor say aye. Aye. Opposed? Motion carried.
Number 19 is case 2012012651. Number 20 is case 2012012652. And 21 is case 2012012653. The complainant states that she went to view her aunt's body prior to the burial, as no one had informed her of the final arrangements. The decedent's power of attorney questioned the complainant about the obituary that her aunt had written, due to some of the people being mentioned in the obituary were already deceased at the time. The funeral director then informed the complainant that the decedent had left her some money, but he never informed her of how much money was left. One policy for the complainant and two policies for another aunt who was already deceased were left by the decedent. The funeral director informed the complainant that one of the policies was actually in the name of the funeral establishment, and that the complainant needed to sign the documents so that the establishment could receive the money. All of this took place on March 19, 2012, and when the complainant had not heard any further from the respondents, she went back to the funeral establishment on April 13, 2012, and asked for a copy of the paperwork that she had signed. The funeral director stated that he would call and ask her for her number and her telephone number again. The complainant states that she waited 10 business days at that point and received a statement that she had signed money over to the mortuary in this case. She then called the insurance company to request a copy of the form and noted that her signature had been forged on one of the documents. Later in the week, she called several times to speak to the funeral director, and he did not return her phone calls at the time. She then asked again for a copy of the form she signed to get the money, and the funeral director said that he would provide that for her. The complainant states that the document she received from the insurance company was a letter that she had never seen previously, and did not actually sign the document herself. In response, respondents 20 and 21 state that the decedent informed them of the insurance policies and that she had taken out to pay for her final arrangements upon her passing. At the time of her passing, the respondent met with her family and discussed the final arrangements for the decedent and any financial obligations that the family was responsible for as well. The family agreed to everything that was discussed, and he had the complainant sign an assignment for the policy that listed her as the beneficiary. Respondent explained to her that this would allow the proceeds to help pay towards the funeral bill, and that the complainant agreed and signed the document. The original document that she signed was damaged in processing, as a cup of coffee was spilled on the document. Thinking that they were already in agreement, the respondent duplicated the document for processing. In no way did he attempt to defraud anyone of any proceeds of any kind. Respondent states that they had an agreement and that the complainant is having a change of heart. The decedent's power of attorney also responded and stated that he had power of attorney over the decedent, that he had acted as power of attorney, and he had acted in that capacity for approximately 10 years. These funeral arrangements had been in place for years and agreed to by the decedent and the respondents. This individual states that he was present at the establishment and witnessed the complainant signing the documents in order for the decedent to be buried. The complainant then sent a response and stating that she spoke further with the respondent and that this matter has been resolved. We found a history of prior complaints. Respondent number 19, we found 13 closed complaints, none related, and respondent number 20 and 21, no prior complaints, and in cases 19, 20, and 21, we're recommending dismissal of these complaints.
Make a motion to accept council's recommendation.
We have a motion by Mr. Starkey to accept council's recommendation.
Second.
Second by Mr. Patterson. Any further discussion or questions? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 22 is case 2012013-211. On April 18, 2012, a field representative conducted a routine inspection of the respondent establishment. The respondent lists one employee in the staff section as operations manager, but fails to note that he is unlicensed. The field representative reviewed 3 business cards, and one of those cards listed this employee as operations manager and CFO. The crematory inspection report was dated March 15, 2011, but the manager called the crematory and received the latest copy of the crematory inspection report dated January 25, 2012. As for the casket price list, the casket price list and outer burial container price list dated January 4, 2012, presented at inspection, both lack basic descriptive information for the units listed as required for these 2 documents. We received no response from the respondent in this case, and we found a history of 6 closed complaints, 2 of those related, and we're recommending a consent order with a $750 civil penalty plus $250 for no response, for a total civil penalty of $1,000 and authorization for a hearing.
Motion to accept council's recommendation.
Second.
We have a motion by Mr. Hinkle to accept council's recommendation, seconded by Mr. Patterson. Any further questions, discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 23 is case 2012013-231. On March 13, 2012, a routine inspection was conducted of the respondent establishment. The cremation authorization form of James H. Price failed to bear the signature of an authorizing agent. Also, the statement of funeral goods and services selected for James H. Price failed to contain any itemization for the $2,985 listed for total funeral home charges in the summary section of the statement. Also, the statement of funeral goods and services selected for John Harry Johnson lists a charge of $995 for a concrete box, but the price for a concrete grave liner on the outer burial container price list was $850, creating a surplus of $145. Also, the statement of funeral goods and services selected for Lance Barnett lists a charge of $895 for a concrete box liner, but the charge for a concrete grave liner on the outer burial container price list was $850, creating a surplus of $45 in this case. The general price list shows a range of prices for outer burial containers as $895 to $6,995. Neither of the 2 prices agree with the actual outer burial container price list presented as being the current outer burial container price list with an effective date of November 16, 2011. In response, the respondent states that the issue with the cremation authorization form has been corrected. Also, the violations of the FTC, the respondent states that this has been corrected and a revised statement was given to the purchaser when the purchaser came to pay the statement. Concrete grave liner overcharge has been corrected on the balance due statement, and credit was given to this account. The overcharge of $45 and a check has been issued in this amount to the decedent's spouse, and the general price list has been corrected as well. We found 2 closed complaints and 1 open complaint and 1 case related, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Move to accept council's recommendation.
Second.
We have a motion by Mr. Highsmith to accept council's recommendation, seconded by Ms. Sale. Any further questions, discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 24 is case 2012013-241. On March 21st, 2012, a routine inspection was conducted of the respondent establishment. The price range listed on the general price list for outer burial containers was incorrect when compared to the prices of the outer burial containers on the outer burial container price list. Also, alternative containers listed on the general price list for sale must meet the definition of alternative containers as provided by the funeral rule. The tray view on the casket price list does not meet the qualifications defined as an alternative container. The following 6 caskets were offered for sale in the casket selection room, but not on the casket price list. The Pearson Cherry for $4,495, the Tapestry Rose for $3,495, the Ivory Mist for $2,495, the Star Cooper for $995, the Athenian for $2,495, and the Cortland Oak for $3,495. Also, 1 outer burial container sample offered for sale in the selection room had an incorrect price when compared to the outer burial container price list. The Regency burial vault sample in the selection room was priced at $2,495, but the same vault was not listed on the outer burial container price list. Also, the statement of funeral goods and services selected of several customers included a $95 charge for bathing and handling of the deceased when embalming is not performed, but the statement of funeral goods and services selected charged the customers for embalming and bathing and handling of the body. In response, the respondent states that the inconsistencies on the general price list have been corrected. The alternative containers, the respondent believes the field representative's reading of the funeral rule regarding alternative containers is very narrow, as the tray view option specifically states that it is cardboard constructed with crepe paper, mattress, and pillow. As for the casket price list, respondent states that the discrepancies have been corrected here. The outer burial container price list, these issues have been corrected, and the respondent states that federal law does not prohibit a charge for bathing and handling of the deceased, but they no longer offer this service now. We found no history of prior complaints, and we're recommending a consent order with a $1,000 civil penalty and authorization for a hearing.
Move to accept council's recommendation.
We have a motion by Mr. Highsmith to accept council's recommendation,
Second.
and a second by Mr. Hinkle. Any further questions, discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 25 is case 20120135551. The complainant in this case states that the respondent references the name of 3 non-licensed individuals without noting that they are non-licensed individuals. The respondent also indicates that the establishment is under local family ownership, but they are owned by a large corporation. In response, the respondent provided a lengthy response to the complaint. However, it is apparent to council that there is no violation in this case. The advertisement was placed in a local publication on May 31st, 2012, and the piece was written by the former, now retired owner of the respondent establishment. While the complainant is correct that the respondent alluded to 3 unlicensed individuals in the piece in question, it is apparent that the writer of the article was providing the name of the new manager, and the 3 non-licensed individuals in question were the new manager's parents and the spouse. There was no evidence that the respondent was attempting to mislead the public in this case. We found a history of 3 closed complaints not related, and we're recommending to dismiss this complaint.
What about the part about being owned by a large corporation?
I still don't think that it's a violation because he's no longer the actual owner or manager of the establishment. He was simply writing about his his current life now that he's retired, and it was in no way written on behalf of the establishment or anything of that nature.
All right.
Motion to accept council's recommendation.
Second.
We have a motion by Mr. Hinkle to accept council's recommendation, second by Ms. Taylor. Any further questions, discussion? All those in favor say aye.
Aye.
Opposed? Motion carried.
Number 26 is case 2012013-831. The complainant states that he and his wife went to the respondent establishment to plan for their funerals. The complainant states that he told the respondent that everything should be included and that he did not want to pay any extra money when the day came, and he states that the respondent told him everything was covered and included. The complainant's wife passed away on January 24th, 2012, and the complainant and the family went to the funeral home to make final arrangements. The respondent explained that the insurance plan grew quite well and even had a surplus of $200, but when the complainant reviewed the paperwork, he found that the funeral was $11,000 and explained to the respondent that something must not be right about that. The complainant stated that he had paid extra on his wife's premiums because he wanted to purchase a rock for her grave with the extra money he would receive. The complainant states that he paid the plan off early and his wife's services came to a grand total of $8,136. And the respondent noticed this and decided to reconfigure the paperwork. At around 1 p.m. that afternoon, the complainant met again with the respondent, who asked him to sign a blank document that would later be filled in. Expecting a price of $8,136, the complainant states that the price came back at $8,775.67. The complainant informed the respondent that this was not correct, and the respondent explained that they brought the price down on the casket so that the sales tax would not be as high, but the complainant stated that he had already paid the sales tax. When the insurance agent who works in the funeral establishment came into his office, the complainant informed the agent that the funeral establishment was overcharging him for his wife's funeral services, and the agent told him that he could not be right and that the only thing they could charge the complainant extra for would be the opening and closing of the grave, the hair, dress, preacher, and clothing, but that the agent agreed to meet with the complainant and funeral director. The three individuals discussed the charges just before the final services took place for the complainant's wife. The complainant states that he later found out that the funeral director did not lower his wife's casket into the grave. The funeral director had to force the casket shut. The funeral director failed to tell the preacher where the grave was, so that the preacher had a difficult time finding the grave, and that the funeral director did not stand where the complainant believes that a funeral director should stand for a funeral service. In response, the respondent states that the complainant and his wife made funeral arrangements on a 10-year payment plan in December of 2005. They purchased a traditional service with an 18-gauge casket and 12-gauge Sazonian vault, which were all guaranteed. However, the items marked non-guaranteed included hairdresser, opening, closing, and sales tax. Also, the flowers were non-guaranteed and they were not included in the initial contract. The complainant was upset because he made extra payments towards his pre-need contract. However, no one at Forethought was aware that the complainant made these extra payments for the monument for his wife's grave, and everyone believed that the complainant was just trying to pay off his account early. The respondent tried to provide a proper response to events that occurred 6 months ago, but there was a lot to recall considering the decedent's 10 siblings attended the planning for the final arrangements. The respondent remembers thinking that the complainant's pre-need account grew very well over the years, which was a surprise to all of the employees considering they had to write off most of the Forethought contracts. The respondent informed the complainant that their account grew very well and even had enough left over to provide for an additional $200 to be returned to the complainant. The complainant then appeared to become agitated and said something was not right, as he had been making extra payments on the account. The respondent then told the complainant that they should have informed the respondent and purchased a monument with the original contract because it was not included in the original contract, so the extra money was going to pay off the pre-need contract. The respondent then decided to call Forethought to satisfy the complainant and ask them to refund any extra money that was paid in and above the monthly premiums. The Forethought employee instructed the respondent that this was not necessary as the complainant had yet to pay off the original contract, but the respondent asked for the refund and received a check made out to the complainant beneficiary in the amount of $2,160.66. The respondent told the complainant and his family what they were doing, and to avoid making the complainant pay any money out of pocket, the respondent only charged the complainant today's prices for opening, closing, and the hairdresser, while reducing the price of the casket from $3,495 to $2,450 to avoid the sales tax. The complainant was still not satisfied, so the respondent took the complainant and his family to see the casket selected by the decedent. The family was pleased with the choice of the casket and later thanked the respondent and told them not to worry about the complainant, as he treats everyone that way. The funeral services then took place, and the complainant's family stopped by the next day to tell the respondent that the complainant was still not happy, as he believed that he should receive the interest earned on the services. The complainant believed he should receive the extra payments plus interest on the account, and the respondent should only receive the $8,136 of the original cost of the merchandise in 2005. The respondent then attempted to explain that the interest helped cover the cost of inflation of the merchandise and asked that the insurance agent come in to explain the situation to the complainant. The agent initially believed the complainant was telling him that the respondent was charging for the difference in inflation of the guaranteed items, but then explained to the complainant that he was actually receiving funeral services for less than the original agreed price of $8,135 set back in 2005. The respondent does not recall the preacher, who was a relative of the complainant, going to the wrong grave site, and that the respondent states that the funeral director stood beside the grave where he always does. Respondent states that they have never been criticized regarding how they conduct funerals or graveside services, and respondent questions why complainant waited 6 months to file this complaint and believes it relates to the complainant placing solar lights at his wife's grave and the respondent removing the lights per cemetery rules, which explain that items left at the gravesite will be removed after 7 days. We found a history of no prior complaints, and we're recommending dismissing this complaint.
We would accept council's recommendation to dismiss.
Second.
We have a motion by Mr. Highsmith to accept council's recommendation, second by Mr. Patterson. Any further questions or discussion? All those in favor say aye. Aye. Opposed? Motion carried. I believe, does that wrap you up?
Yes, that does.
All right. Thank you very much. I think the next item on our agenda is we have had a request by Mr. Michael Kevin Knowles to address the board this morning. If you all would come forward. And I might,
Mr. President, members.
I might want to remind you all to speak clearly into the microphone. And it's always been my personal opinion that a licensee ought to have the chance to address the board if there's an issue. And just for the record, we would like for you to state your name and your reason for being here today.
My name is Michael Kevin Knowles, and I'm here today to seek my embalmer's license by reciprocity from the state of Texas.
Okay. And you realize today that you will only be addressing the board, and unless we, after you speak your piece, unless we hear a motion to reconsider or rescind the action of the last board meeting, that action will stand and we'll move on to the next item on our agenda. Okay.
And Mr. President and board members, my name is Michelle Owens with the Nashville Bar. I'm representing Mr. Knowles, and this is my associate, Michael Gillespie. I believe you should all have received a 4-page brief that was submitted earlier, and I think they said it would go on your iPads. If you do not have those, I'll be glad to provide you with one. Does anyone not have that?
We do.
Okay, thank you. Okay, for the record, I have a court reporter here today. I'm one of those who hopes for the best and provides for the worst. So in case this were to go into Chancery Court, I would like to have an accurate record. So I am placing as Exhibit 1 with the court reporter the brief that you all have that has been submitted to you on Mr. Knowles' behalf. I also have a stack of documents that I believe you already have, all of these documents with the exception of perhaps the first page, that I would like to present as collective Exhibit 2 for the court reporter. You need to pause for a minute? Okay. And can we pass these out? Can we please?
Let me ask legal counsel a question just a minute. Now, this item is not really up for discussion or debate at this time with the board, and you're only here to address the board, and we'll have to have a motion to reconsider if we're going to go in depth in this. Is this not correct?
Yeah, the board, I'm Adrian Shute, Assistant General Counsel. The board hasn't voted to reconsider what it did the last time yet, so it's really not appropriate to be passing out information.
With all due respect, I'm trying to make a complete record, and I don't think there's any violation with getting the documents on the record. I mean, if you're objecting to that, then please object. But otherwise, I would like the record to be complete with the documents.
You know, this board is governed, and we adopted Robert's Rules of Order at the beginning of the year, and we're going to stick with that. You know, you have a request to address the board, and you can make your statements, and then we'll see what the will of the board is, whether we're going to reconsider or not.
And I understand that. I'm a little bit confused about whether the council have an objection to admitting the documents.
Well, I don't think the board doesn't have to make a formal objection. What I'm saying is, you've not laid a foundation for passing out. I mean, you just come in here, you're just passing out information.
I am.
Anything you pass out is not relevant unless the board is considering that, which they haven't agreed to do.
And I am putting them in the record for identification purposes. They may or may not be relevant, and I'm not asking them to be accepted as relevant.
So, I mean, you could just as easily send one copy of these to the board, or...
I'm just not understanding.
Are you asking the board to consider what you're passing out?
No, I'm not asking them to consider it. I'm asking to put it into the record.
What record?
The record that the court reporter is making of this.
Okay, but you understand this is not a contested case proceeding here.
Well,
So, there's
that's your opinion.
Mr. President?
It is not. I can answer that question for you.
If I can address the board for just a minute, please.
Ma'am, that's what we've been waiting on since you came up here, is according to our agenda, Mr. Knowles has a request to address the board, and that's it.
And that's what I'm trying to do, and I am going to address the board in the manner that I feel is most appropriate to represent my client. Mr. Knowles was here previously and requested an embalmer's license through reciprocity. He was given his funeral director's license through reciprocity, but denied the embalmer's license. And if you would like to follow along my brief, I'm not going to read it to you, but if you want to look at the codes that I'm addressing, they are in the brief. And on page 1 of my brief, it addresses the qualifications that you need for reciprocity. If you are applying for reciprocity, you do not have to have the educational requirements provided for in the state of Tennessee for a new licensee. If you are applying for reciprocity, all of those can be met if you look at number 3, where it says that if you've been licensed for 5 years and have practiced as a funeral director and embalmer and or embalmer. Now, the board seems to have had an issue before that the 5 years were not immediately preceding Mr. Knowles' application for his embalmer's license. And with all due respect to the board and to council, there is nothing in the state code that states that this requirement of the 5 years be immediately preceding and consecutive. It doesn't even have to be consecutive. If you look at the code clearly that's on page 1, and it's 625311, number 3, it clearly states that the provincial authority of another state has licensed this individual in good standing for 5 years, and he's been employed as a funeral director or embalmer or both. Now, if you look at the Tennessee Code 625201, which is on page 2 of my brief, it deals with the requirements for board members, such as yourself. And there is a very different requirement for board members, and reasonably so. You are the hearing division of the body. You make decisions based on what other members of your profession are doing. And for board members, it is required that all of you possess a minimum of 5 consecutive years' experience in the state immediately preceding your appointment to the board. Now, the reason it's important that you notice that is that these two codes were not written in a vacuum. They were written all at once. And when you look at the many cases and multitude of case law that addresses statute construction, you look at the plain language of the statute, and you take it for what it is. If a word is there, it means something, and if it's not, it means something just as clearly. In this case, the fact that the legislature and General Assembly chose to put in the consecutive 5 years experience immediately preceding the application for the board members and chose to withhold it for applicants through reciprocity clearly means that there was no intention that Mr. Knowles need to be practicing the 5 previous years before he applied. Mr. Knowles has met all of the requirements. He has been licensed since 1980 in good standing in Texas. He still has a current embalmers and funeral director's license. He has practiced for 19 years. He paid the fee. He got a scaled score of over 75 and has provided all of the documents to you that you need. There is no legal reason that Mr. Knowles should be denied his embalmer's license based on the Tennessee law. Now, I understand that I think I was told previously this is the way it's always been done and you're looking at precedent, but precedent can't overrule state law, and the state law clearly says that you just have to have 5 years of experience in good standing, which Mr. Knowles does. And my guess is that previously you've had people come before this board who are in their first 5 years of practice and want to move to another state, and so it has not been an issue before. And so they've obviously been practicing up for the last 5 years. Mr. Knowles has been practicing as a manager of many homes, and so he wasn't practicing as an embalmer for 5 years, although I think he was practicing for the last 4 years. So there were 4 previous years of experience for that. Basically, my point here today is that, respectfully, this board is violating state law in denying Mr. Knowles his embalmer's license because you're in violation of the statute if you do not follow it, which says that you have to provide it if he meets the requirements. And we've been given no understanding that he has done anything contrary to the requirements. And that's all I have, and I would love to answer any questions that anyone has.
Thank you for finally getting to the point. And I want to correct one thing that you made mention of. The board did not deny him his license. If we had denied his application, he would have lost his application fee. If you go back and read the minutes of the meeting, there was a motion to give Mr. Gribble the authority to approve him for licensure once the requirements were met. The board could have outrightly denied his application, but it wasn't. And I want to make mention that during the meeting that this board made its decision in the most thoughtful and sincere manner that we knew how. We acted in good faith and at the advice or with the advice of our legal counsel. And as I have stated before, thank you for your remarks, but if there is not a motion from a board member to reconsider or to rescind the action of the July meeting, we'll thank you for your appearance and we'll move on to our next item on the agenda.
Give them a chance to make a motion.
That's what I just said. If I don't hear a motion, then, the previous ruling will stand. And the chair will entertain a motion of any kind. Going once, going twice. Thank you all for being here today.
I would like it noted for the record that Mr. Knowles intends to appeal this to Chancery Court on the basis of a contested case under the Administrative Procedures Act and under a writ of mandamus. Thank you.
Next item on our agenda, we have Administrative Matters. Mr. Robert Gribble, Executive Director.
Thank you, Mr. President. The first report we have is the licensee report. This is a report of licenses that were administratively approved by the Executive Director pursuant to the Board's authority for the period of July 10 through August 13, 2012. Establishments, a change of ownership, a change of location, an establishment name change, and then individuals. 2 individuals received a funeral director and embalmer's license, 1 individual a funeral director and embalmer by reciprocity, and 1 a funeral director by reciprocity only. Next item is that, well, there are no closed establishments for this period of time since the last board meeting. Next item is the disciplinary action report. This is a report of the consent orders administratively accepted or approved by the executive director pursuant to the board authority for the period of July 10 through August 13th. You see those listed there. The open complaint report. As of yesterday, August the 13th, 2012, there were 121 open complaints. Mr. President, that concludes my report.
Chair will entertain a motion to accept the executive director's report.
So moved.
Have multiple motions. Motion by Mr. Patterson, the second by Ms. Sowell. All those in favor say aye.
Aye.
Opposed? Motion carried. Next is the approval of, I believe, individual license application. David William Trevette. Okay, if you come to the witness stand. And if you will, just for the record, speak into the microphone, tell us your name and what you're here for.
Okay. It's David Trevette, and candidate for licensure for a funeral director in Embalmer.
Okay, thank you. We've got a lot of documents to go through here, so
Yes,
you
sir.
just bear with us a little while.
Yes, sir.
Mr. President, me and Mr. McDonough were looking at this, and we both agree that on his application for a Embalmer's license, on number 2, he really should have said no on that. Because he's not being convicted of a felony misdemeanor. Pled under an expungible probation. And, I mean, perhaps he was just trying to be as forthcoming as possible, but that really should have been no.
Legal counsel, then, had that been checked no, then I could have administratively reviewed the application for approval, correct? That's the reason he's here today, is because he was being completely forthcoming and wanting to not have any question later.
All right.
So it's not relevant.
Really, is that correct? That's correct.
So in other words, you would have granted his license,
Yeah.
and not checked this.
I make a motion, we accept this application.
We have a motion by Mr. Starkey and a second by Ms. Taylor to approve this application. Any further questions? All those in favor say aye. Aye. Opposed? Motion carried.
Thanks, sir.
Mr. Trevette, might I say, the board greatly appreciates your coming today to clarify this issue.
Yes, sir. Thank you. I
And
appreciate
being
your
so
consideration.
forthright.
Thank you. I appreciate it. Thank you so much.
And are you employed here?
Yes. No, sir. I'm in Knoxville.
Oh, okay.
By mine at funeral.
Okay, so
Yes, sir.
you've driven a pretty good ways too.
I have, yes, sir.
All right. Thank you for being here.
Thank you. I appreciate it.
Congratulations.
Thank you.
Let's see. Mr. Gribble, is that the only individual that we have?
That is the only individual. You have 2 establishments.
Okay, let's see. All right, next would be cremation by Grandview. I believe those gentlemen are here. And again, we got a bunch of pages of stuff to look through, so just bear with us. And if you would, just tell us your name and reason for being here today.
Sure thing. I'm Lynn Gibson. I'm here with my business partner, Jason Chambers, and we have submitted to the board an application for an establishment license.
Okay.
Mr. President, I might point out that, not on your iPad, but in the information that Mr. Gibson and Mr. Chambers gave to me this morning, there is a letter that clarifies the zoning and the parking. And I shared that letter with Mr. Hinkle only prior to the meeting, so if you have any question about that, Mr. Hinkle, who is our board expert in that area, is familiar with that letter. And also they provide an amended application just to clarify the ownership of it as being by cremation of the Grandview Incorporated Corporation. In your documents, there are some photographs, and I know that those aren't very clear on those iPads, but there's an email from Mr. Bill Luna, who's the field representative there. The email is dated August the 1st. It kind of explains the layout of that building. It's about the 3rd or 4th page from the front, or 5th or 6th page from the front.
It's a nice looking building from what I can tell on here. Give us a little background of what you all are doing.
Yeah, absolutely. Of course, we have funeral home already existing there in Maryville and Blount County, and Smith Funeral Cremation Service, and we've got a very good business, and we feel like a very good job in our community, continuing to reach more and more families every year, and that's been the good news. We have noticed in the last several years number of calls. This is, of course, nothing novel, nothing new, to particularly in light of what we've been listening to today, but a number of calls that continue to come in of families not wanting traditional funeral services. And what we're seeing is kind of an exodus of families in our Blount County area wind up going to Knoxville and for more simple, affordable, low service or minimal service cremation options. And we have thought it would be wise at this point. We have the facilities, like you mentioned, there to perhaps offer an alternative in our own community that would address this need. So we do believe it'll be addressing a different market segment for our community, and think it's something that it's time for us to do.
Okay. And if you have requests for embalming at this facility, will it be done there or over at Smith's?
It'll be done at Smith's.
Okay. Okay. All right. And I noticed that you provide pet services too, and of course you realize that we don't regulate the pet services, but we do. I think last year before last, we did set some guidelines in order for that to be a separate bit. Nothing against that type business, sure, but keeping it separate from the humans.
Right.
And have you? Did you look at the minutes back then and see what all that everybody's being asked to do?
Absolutely. We actually had help from our own council to help make sure we understood those provisions, and just sort of in a nutshell what we did there in our Grandview location where our pet services is located is that we made sure we complied with, I probably won't remember them all, but we do have the things such as a separate name, separate phone number, separate entrance. It's all, it's its own location there. Separate address, separate website, separate business cards, We've
I
tried to
noticed in here,
separate it.
there's no way inside to go from that to any other part of it.
Correct. You actually have to exit the building, and we've got some signage we will put up if it's time to do that, and that way you'll be able to exit the cemetery part and then go around to the pet services part, but you can't actually go. There's a physical wall now that we built.
Okay. That's good that you noticed that beforehand,
Yes.
not after.
I read Mr. Luna's email in here, and you got by him, so it looks like you got it done.
He stays on top of that.
He's very thorough.
Well, save you trouble in the long run.
That's exactly right.
Try to get it right the first time.
So everything's in order.
I make a motion, we accept the application.
We have a motion by Mr. Starkey to approve this application for an establishment.
Second.
Have a second by Mr. Patterson. All those in favor say aye.
Aye.
Opposed? Motion carried. Congratulations.
Thank you guys very much. Appreciate your time this morning.
Your trip paid off.
Thank you.
Thank you. And next we have Peebles Fayette County Funeral Homes and Cremation Center. All right. And if you would, just like the others, just give us your names and your reason for being here, and be sure you speak into the microphone so the tape will pick you up.
I'm Michael Tillman. I'm kind of the overseer of the funeral homes for Mr. Peebles, and this is Lloyd Shelton, who will be the proposed manager for the new establishment.
Okay. And is this a brand new facility?
It is, yes, sir.
Read.
Give me, if you would, give me a little background on this particular location, because I'm looking at a letter that says no services, embalming, or preparation is to take place at this facility.
That is correct. Of course, we're family owned and operated, have been since 1884. We have the two establishments now, one being in Somerville and the other at Oakland. We thought that it was time. The southeastern part of our county is really growing and is right on the border of Collierville and Shelby County, which is one of the fastest growing areas in the southeastern region. So we felt like it was time to really start working that area with pre-need, and we wanted to be able to do that out of an establishment that was closer to the area. So that's going to be the primary purpose for the establishment, is to offer pre-need.
But it will be a full chapel, if you want.
No, sir, will not. It's strictly, and that's why in the name, we didn't want to mislead anyone. We wanted it to be an office. So that's why you see it reads Pickerton Office on the application. We have the other two chapels there in the same county, and we feel like that's sufficient, as far as if someone wants to have a service there at one of our chapels, we have that to offer.
So you just putting the pre-need office in that location?
Yes, sir.
Will you have a casket room there and stuff like that, or just?
No, sir, we will not.
Okay. Oh, just pre-need strictly, so book or
Yes, sir.
TV.
What if you had an at-need? Would they have to go to either Somerville or Oakland?
That is correct. Yes, sir.
You won't do anything there except make pre-arrangements.
That's correct.
But you'll have representatives setting pre-need, and that's just where they can,
That
it's
is
just the
correct.
headquarters.
That is correct. Yes, sir.
Mr. Gribble, is it just that this is a little different situation, the reason that it's before us today?
Yes, sir. It doesn't have any facilities for viewing or visitation, funeral ceremonies. It's just-
Okay.
So a deceased human body will never enter the premises of 3725 Highway 196. Neither will there be any funeral services there, any visitation, any identification, or anything of a deceased human body.
That's correct.
I know we've been down this road before, but I don't see the need for an establishment license when an establishment license is to be granted to a facility that's dedicated to the care and preparation of deceased human beings, and no other activity shall go on at that place other than what's incidental to the care and preparation of deceased human beings. And I don't see anything at this location that has anything to do with the care and preparation of deceased human beings.
Is
Not
this,
at 3725 Highway 196, Suite C.
Other than an arrangement center.
is this to make people aware that you're in the community?
Well, that would be one reason to have the office, just for the awareness. But you would need the office, for it's about 30 miles from that end of the county to our nearest location, distant. So we feel like we need to have an office there to where we can market our business as well as the pre-need. Again, that's the fastest growing area.
People will come in and you will make pre-arrangements with them you have an office there where you sit down and talk with people, and
That is correct.
you show them your casket selections and all that, either on a kiosk or an iPad or something like that.
Yes, ma'am. Yes, ma'am.
If If I may interrupt, under the definitions of funeral establishment, it states that funeral establishment means any business, whether proprietorship, partnership, firm, association, or corporation, engaged in arranging funerals. That's included in the definition, and I think if they're providing pre-need funerals in this case, then that would definitely fall under that definition. So I would think that they would need a license, in this case, establishment license.
I would think if you had an office like that, if somebody died in that part of the county, you could still make regular funeral arrangements too, and then they would just use one of your, instead of them having to go all the way 30 miles away.
You could meet with an at-need family
Sure.
to make those arrangements if you wanted to. I guess I'm kind of old school too. I'd love to show caskets, when it comes to actually making the arrangements.
Sure.
On a pre-need, it's a little bit different because they do, we can give them the opportunity to see a picture of a casket, but we also can invite them and give them a chance to actually see the casket on a pre-need. But on an at-need, I prefer to show them the actual casket.
And again, I guess this goes right back to the same thing we've had time and time again. This is a storefront, and legal counsel. Do you see any legal reason to deny this application?
No.
Okay. All right.
Motion to approve.
We have a motion by Mr. Hinkle to approve this application, and a second by Mr. Patterson. Any questions or discussion? All those in favor say aye.
Aye.
Opposed?
Nay. Not aye, but nay. I'm sorry.
Motion carried. Let the record reflect it. We had one no, Mr. Highsmith. Thank you all.
Thank you.
Yes, sir. Thank you for being here. Let's see. Next on our agenda is rule changes. We're going to go back to Assistant General Counsel Benton McDonough.
Thank you, Mr. President. If you look on your iPads, I believe you have the updated recommendations of rule changes for the Board of Funeral Directors and Embalmers. Better.
Do we need to ask Adrian if you have permission to pass those out?
That's why I sent him away.
I was hoping to serve the remainder of my term out without having one. It's part of it. That's life. That's life.
All right.
All right. If you'll notice on your first page at the top, under 0660-03-.04, that deals specifically with renewals. Under funeral director, we removed the part that states that the fee for biennial renewal of a funeral director's license shall be $275. We took out the $275, and we are replacing that with $235, as we previously discussed.
We're lowering the renewal fees for funeral directors and embalmers to $235. And we've had, I think there's been discussions that's gone on with the higher ups, and the board has the ability, we're on sound enough financial footing to do that.
That's correct.
And this is good.
Okay. And also, you'll notice there in section 2 that we also did that with the embalmers, lowered it to $235. And then, do you want to go on to the next one?
Yeah,
from there?
just go on. The establishments will stay the same.
Establishments will remain the same. Under 0660-03-.05 reciprocal licenses, we also lower the fee for reciprocal funeral directors or embalmers license. It was set at $100, and that has been set at $235 to be in line with the license for funeral directors and embalmers that are already practicing in the state.
Does their license say reciprocal, or does it just?
I think it's just regular.
That's what I thought.
And then we also wanted to add subsection 3 on here to clarify the board's interpretation of 625311, and we're going to add. We would like to add the language that any non-resident applicant for reciprocal funeral directors or embalmers license failing to meet the minimum qualifications described in TCA 625311B2, based solely upon a failure to meet TCA 625305B6 or B7 for funeral directors, or TCA 625307B6 or B7 for embalmers, may meet such qualifications provided that the non-resident applicant has been licensed by another state or provincial authority in good standing for 5 consecutive years immediately preceding their application, and has been employed as a funeral director or embalmer or both for such time. And why we believe that the rule already states this, based on how the board has interpreted that statute, we just want to make it clear to the citizens of Tennessee that's the court, or that's the board's interpretation of
We're
that
just
law.
making it abundantly clear.
Yes.
Now, would this been better? Does this do the same thing the discussion did earlier?
Yes.
But it kind of clarifies it.
It clarifies it for
In other words,
for citizens. Yes.
she had 2 points, one for a board member and one for the other. This just kind of makes it equal for
Yes.
everybody, right?
That's our belief. Yeah.
Okay.
Yes.
This takes away the gray area, if there is any.
And next, under Rule 0660-05-.01, under Applications, if you'll scroll down to subsection F on there, and we wanted to add some language dealing with the quarterly reports of apprenticeship training, and we wanted to make it clear that the applicant for a funeral director's license has completed not less than 2 years of apprenticeship as a bona fide paid employee of an establishment working not less than 40 hours per week in the presence of and under the direction and supervision of a licensed funeral director. And then we wanted to add the language as evidenced by the applicant submitting quarterly reports of apprenticeship training within the allotted time throughout the duration of the apprenticeship. And that allotted time is 60 days after the I guess the close of the time that of that quarter that the time is being reported for. That's also stated in another rule that they have 60 days to do that. So we wanted to add language.
Why 60 days? Why would you need 60 days to fill out a one-page report?
I think we just want to make sure that they had the time to get the report in, and I think previous boards have felt that 60 days was a proper amount of time to give them in that case.
Could you put right there, C, like in a comma or something, see the section that says the 60 days,
Well,
so it's clear.
Well, we've already got the rule
It's
in
al-
place that states
already there.
that they have the 60 days.
Yep. The only changes are being made are the ones he has underlined, I believe.
Yes,
That's the only
that's correct.
changes being made.
And under subsection 2, that the same rule deals with embalmers as well.
Right.
Now going down to civil penalties under 0660-08-.01 civil penalties, you'll go to the end of that section, and it gives a list of basically factors that the board is supposed to take under consideration when considering the proper civil penalty for a respondent. And we added section G on there that says that the length of time that has elapsed between the alleged violation and the filing of the complaint, because I know that one of the issues that was brought up by the board previously was that you all wanted to, I guess, have some control over, want to take into consideration, how long it's been since the actual violation occurred. And I think that this is probably the best way to confront that issue, and I think it's just something that you guys can take under consideration every time you're listening to a complaint.
For instance, if consumer files a complaint 2 years later,
right,
and we wanted to wait 2 years, and
right,
that would have a variance on the severity of the penalty.
And I think, I think you could take that into consideration in this case.
Is it necessary in this section to address a no response?
We already have that.
Okay.
The no response is already covered somewhere.
Yes.
But it doesn't need to be in with this group here, you don't feel?
No, it's already, I think it's under professional conduct in that case. And then next we have under 0660-9-.01 requirements for a crematory. If you'll scroll down to number 4, and we're going to add language that says, in the event that the urn or other container is insufficient to accommodate all of the cremated remains, the excess will be placed by the crematory operator in a secondary container. The secondary container shall be kept with the urn or other container and handled according to the final disposition instructions set forth by the authorizing agents. And then if you'll scroll down a little further under 8A, which was I believe that was, let me see, okay, yeah, under 8A, it states that all cremations of human remains in this state shall be arranged through the holder of a valid current funeral establishment license issued by the board. And then the new subsection B will state that all cremations of human remains in this state shall be directly supervised by a licensed funeral director during the cremation process, including but not limited to the placement of the remains in the cremation chamber, repositioning of remains, removal from chamber, processing, and placement in an urn or other container. And then further down on subsection 9, it originally stated that each crematory shall submit its cremation authorization form to the board for approval prior to using the said form. And we're going to add language that every funeral establishment shall use the cremation authorization form approved by the board and provided by the crematory where the human remains are to be cremated.
Mr. Counsel, back up in subsection B, and I'm in full agreement. The licensed funeral director needs to directly supervise all of the activities regarding cremation. Do we need to address at this point that licensed funeral director also be a certified cremationist, in that just being a licensed funeral director doesn't necessarily mean that he knows how to cremate a body. Is there concern about that? I certainly think that I'll leave it at that.
I don't think what we're doing here is we're just taking away the vague language of number 7 and replacing it. We certainly could do that, but, we're just, with what's in 8A and B, we're just making more plain what's expected now. We're not adding to any requirement. We're just making it, again, abundantly clear as to what we expect. And
I just feel that the licensed funeral director needs additional training as well.
I don't know that all of them do. Most of the funeral directors who are the manager at a crematory do take an extra educational program where they're certified as a crematory operator. But I don't know that all of them do, but many of them do. And probably if you went that far, I don't know, legal counsel could tell you, but you're probably going to have to set out the program then, and what qualifies the person to meet the requirement of a certified crematory operator or cremationist, whatever terminology you want to use.
Yeah, right now.
I think with cremation, that's the biggest place for lawsuits in the funeral industry. I would hope if I was the manager of a crematory, I want to make sure everything's being operated right, and whoever's handling my chambers know what to do. So I don't know that additional regulation is necessary there. I almost feel like with the vulnerability of a lawsuit, you're going to be as careful, and we've all seen, and just even careful crematories have been sued and judgments because wrong ashes put in, so I think every time somebody's sued, they get a little more careful.
I think they should be, and I think we've talked about this before, but there was a movement out there, as we're all aware of, by a handful of people. And I think if we push the issue, if we go and put that you have to be a certified crematory operator and whatever program that we decide they need to have, and I'm afraid they're going to come back and say, okay, yeah, we'll do that, but we want our funeral director to go home. We're liable to be hit with that again. And by doing this, we're just making it, again, abundantly clear what we expect.
Who's responsible?
Yes.
I have a question. A person called me since I've been on the board and asked me about it, and I told him I was unaware, but I would seek. An inspector went to a funeral home. A funeral home picked up a body and embalmed it and shipped it out of state. Subsequently, the funeral home out of state cremated that body, So they called the funeral home back to go through the proper, once they found out that, in other words, they had a funeral, then the family decided they wanted to cremate, so they had to come back to the funeral home to get the authorization from the county, go through the necessary for the permit from the county. But the inspector said that because he did that, he had to have a copy of the license and everything from that other crematory in the other state, even though he was not involved in the cremation, because he was the one that secured the medical or the authorizations, from the medical examiner. Is that kind of a gray, or I would have never thought about if I just picked up the body and embalmed it and shipped it, that I would have been responsible to have on my file the crematory operator license and that type of thing. So I told him I would check, but I could not give him a...
It does say that that you have to have the latest inspection report and the license of the crematory utilized by that funeral establishment, and I think it would come down to what exactly the definition of utilized is in that case. Is it someone that they hire on a regular basis, or is it someone
Well,
that...
this went to another state, though.
Yeah.
And the family afterwards decided to cremate.
Yeah.
So, the body was picked up, embalmed, and shipped.
Probably what depends on is exactly what the funeral director in Tennessee did. Did he just go obtain the permit from the health department, or did he actually get the cremation authorization form filled out?
I think he got the permit, and that's where it triggered it, because when the inspector was inspecting the, folders, he saw a permit in there, but no cremation. And he explained to him, said, well, I shipped that body. The family decided a week later or 3 days later they want to cremate it. So he called me back, and I went to the medical examiner and got this and sent it to him. But he, of course, had it in the paper trail there, But he did not. The family, in other words, the crematory in another state cremated the body. The family signed off in the other state, but they wanted to get an authority from the state where the body died before they would cremate it. So,
if that be all that the Tennessee funeral director did, I wouldn't suppose that he would need the. But I can tell you, Mr. Starkey, sometimes when people call and represent things to you, Paul Harvey says they don't tell you the rest of the story.
Right. Well, he did tell me. He said, now, the inspector did not write me up, but he told me in the future something like that happened. So I did the same thing a month later, but I picked up the body and embalmed it, and then they called me back. So I had him send me an inspection from the crematory. I put it in my file, so I wasn't going to take a chance. And it went out of state. So
better safe than sorry.
Yeah, better safe than sorry. So I thought, well, if that's the case, then I want to be right.
You would be bound by the laws of the state where the cremation occurred, would you not? And not where the death occurred.
I think it would be both. I mean, just for, they took the body and had it embalmed. They weren't aware that the body was going to be cremated, right?
Not originally.
Yeah.
And the body was cremated in other states, so.
Right.
But that other state crematory wouldn't cremate it without a medical examiner. I'm sure they had rules, and so they came back to him to get a.
I would think that they would just be bound by our rules because in our statutes, because they are licensed here in Tennessee and not licensed in, as far as I know, in the other state.
Sure.
So.
Well, that's what I told him. I said, I feel like you getting the permit triggered that. Mm-hmm. Otherwise, nobody would have known. If I ship a body and somebody cremates it without my knowledge in another state, then how they got the permit, or if the other state cremated it just because of the family,
mm-hmm.
and you had a signed death certificate. So, and some states are pretty lax about who can sign cremation forms.
Number 11.
Number 11, we're going to add language that states that at no time shall any crematory be used for any purpose other than the cremation of a dead human body, or of dead human bodies, excuse me.
And that coincides with the language we have about preparation rooms.
Right.
All right.
And number 12, I know that there are several crematories that aren't always sure what to do with metal parts and things of that nature after a body's been cremated. We wanted to add some language that would address those objects and those devices that are left. We're going to add language that states that any funeral director, embalmer, or crematory operator who obtains specific instructions or authorization as required in TCA 625507F to remove any prosthetic devices, pacemakers, implants, metal hinges, latches, nails, screws, staples, plates, or any other artificial device or structure from a dead human body prior to the cremation or from the cremated remains after cremation, the funeral director or crematory operator shall dispose of the prosthetic devices, pacemakers, implants, metal hinges, latches, nails, screws, staples, plates, or other artificial devices or structures in a lawful, non-recoverable manner so that only human bone fragments remain. While the funeral director or crematory operator may receive compensation from a recycling company for retrieving these materials and shipping them to the recycling company, the funeral director, embalmer, or crematory operator shall not receive a fee for doing so that exceeds the actual cost to the crematory facility for performing or assisting in the removal and shipping cost of those materials. And
Wonder if something, I know it's not up to start adding things, but because of gold price, we're having more and more, and of course we will not do it. Something stated in that something about gold, you know, or precious metal might be a better word for it. Does gold burn up, or was it just melt and being little balls in the retort? I don't know.
Yeah, I think it'll still be there.
And I thought it may fall under artificial device or structure from dead human body, but I mean, if you all would like to add something specific to.
Let's see.
Well, the only thing I'd want to do is kind of protect the funeral home from, we will not remove, and I haven't found any dentist. I tell the family, if you want to go, you'll have to find a dentist that will come and do it.
I
They
believe,
usually back
Would that
off
be
then.
considered a prosthetic or
I
an
believe-
implant?
I believe most crematories have a disclosure on their form, something about dental gold.
Yes. I know there's a, I believe we already have a rule in place that addresses.
All dental gold shall be returned to the funeral home where the body came from, which will be given back to the family.
There it goes with the ashes.
While we're looking that up, so the crematory is not selling the devices,
That's correct.
but they can charge a fee for recovery.
For the actual service that they
So
provided.
They receive the actual cost. How are we determine what the actual cost is?
Based on my research, I mean, it's really left up to the funeral establishment or the crematory to determine, you know, how much they'll charge for that service, but they can't make, basically can't make a profit off of it. They're only supposed to cover the actual cost of the service that they're providing.
And you're not charging that to the family, so it would not have to be on your bill of goods and services.
No, that would be
or
to
your
the
statement of goods and services.
recycling company.
He's listening. That's good. Glad you stayed.
You really learn a lot.
Mm-hmm. Yeah.
So you can't sell the devices, but you can charge
For removal.
to remove them.
And shipping costs.
But the act of cremation is going to remove them, is it not? But it's, I guess, physically taking them out of the.
What many of the crematories do, they either donate this to a recycling company, just say, here it is, but you've got to get it shipped to you, you've got to pay the shipping cost to get it to you from our crematory establishment to the recycling company, or they will either get the recycling company to make a check to a charity, and actually the crematory never take the money. It just, they send it all to the recycling company, and whatever the recycling company's gonna pay for it, they just get the check made payable. So there's no appearance of any impropriety.
In reviewing application form for crematories, do you ever see that referenced in some of their
Yes.
things?
And we
As to
just-
how they're going to dispose of the prosthetic devices?
And that's one of the reasons why we talked and thought it was important to put it in rules, so that everybody understands, and that everybody understands what the board's guidelines are for that.
And, I'm sorry.
I'm just gonna say, Mr. McDonough can tell you, but it mirrors the statute, you know exactly what the statute says about it.
Under 62.507F1, it states that,
what page are you on, please?
110, I'm sorry. States
Easier to
that
find by page number. Okay.
no operator of a crematory facility shall remove any dental gold, body parts, organs, or other items of value from a dead human body prior to the cremation or from the cremated remains after cremation unless the operator was acting under instructions that specifically authorized the removal of any dental gold, body parts, organs, or other items of value. No operator of a crematory facility who removes any dental gold, body parts, organs, or other items from a dead human body or assists in the removal shall charge a fee for doing so that exceeds the actual cost to the crematory facility for performing or assisting in the removal of those materials.
That's the question.
All right. Moving on under professional conduct, 0660-11-.05. We are going to add a new section F, which states that an embalmer shall make every reasonable effort to return viscera to the body cavity for final disposition. In the event the embalmer is unable to return the viscera to the body cavity, the viscera shall be placed in a non-porous container, labeled as such, and disposed of in an identical manner to the remains. And Section G states that licensees shall obey any lawful order entered by the board. And next, we wanted to add some new language under quarterly reports under 0660-4-.02. The current rule states that apprentices shall submit a quarterly report of apprenticeship training on a form prescribed by the board. Such report must be received no later than 60 days following the last day of the quarter for which credit is sought. And we want to add language that states that failure to file the quarterly report of apprenticeship training within the allotted time shall result in such credit being denied for that period of time.
Good. Everything looks good. Do we need a motion to accept these and have a public hearing in October?
Well,
to that effect?
What I would like to do is,
we have to adopt this?
I guess, have a motion to adopt those, and then we can go through the Regulatory Flexibility Act.
Okay.
And make sure that...
That's one question. Is it just me, or maybe it's just me, under number 11 up here, no time shall any crematory be used for the purpose other than cremation of dead human bodies?
Mm-hmm.
I know we're referring to a human crematory.
That's correct.
Not a pet crematory.
Right. They can provide cremations for pets because it's a separate business.
I know I can't do one in a pet crematory.
Right.
Okay, and we don't regulate pet crematories. But that, to me, you know, somebody that didn't understand what we've been through, I just looked at that and I thought, any crematory. But I know it's any human crematory. Okay?
Yeah.
Okay.
What that does also kind of prevents them from handling funerals out of there, doesn't it?
It just makes it abundantly clear that there's not supposed to be any animals in there. Okay, so we need a motion to...
I guess you could just to adopt those.
Okay, Chair will entertain a motion to adopt these rules as printed.
I make a motion that we adopt the rules as printed.
Have a motion by Mr. Starkey.
Second.
Second by Mr. Highsmith. All those in favor say aye.
Aye.
Opposed? Motion carried. All right.
I think the gentleman back here had a question.
Let me go back.
I had an unrelated question, I guess. What about a person whose leg has been amputated? How does that fall under the cremation guidelines?
Well,
we have been asked by a family member to cremate his leg that was amputated. Now, we haven't done this yet. That was one thing I was staying to ask Mr. Gribble about.
Well, I think we
Oh,
can't
just
really,
the leg.
we can't,
Just the
Oh,
leg.
yeah,
we can't really discuss that today. We'll have to wait till the public hearing to have any input or any questions like that.
Good question, though.
Yeah. I mean, you can't get a cremation permit because the
Body
person's not
part.
deceased.
And hospitals do
You can do an authorization.
have that done too, so, yeah. That's a good
And
question.
it's not, it doesn't appear to be addressed in our law book, so that's the only reason I asked.
Good question.
All right.
That's a good question.
Can we, I'm going back to, can we push this on and have our public hearing in October?
I don't want to give a firm date on that, but I mean, I would think it has to be no earlier than 45 days after we file the rulemaking. So I'll file this week, and it's 45 days from, at least 45 days from that time. So
Do you know how many days that is?
45 calendar days.
Ought to be about 60 days now to the next meeting, hasn't it?
I think so, yeah.
Give or take a day or
Yeah,
two.
okay, because we want to go ahead and get this done.
Yeah.
All right, next you're going over the
Gotta bring in some extra chairs.
Regulatory Flexibility Act.
The Regulatory Flexibility Act under TCA 4-5-401 requires that prior to initiating the rulemaking process pursuant to TCA 4-5-202A3 and 4-5-203A, all agencies shall review all proposed rules and the effect that proposed rule has on small businesses. The Act requires that each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The Act further provides that the agency shall consider, without limitation, certain methods of reducing the impact of the proposed rule on small businesses while remaining consistent with health, safety, and well-being, and those methods are as follows. The extent to which the rule or rules may overlap, duplicate, or conflict with other federal, state, local government rules, the clarity, conciseness, and lack of ambiguity in the rules or rules, the establishment of flexible compliance and or reporting requirements for small businesses, the establishment of friendly schedules or deadlines for compliance and or reporting requirements for small businesses, the consolidation and simplification of compliance or reporting requirements for small businesses, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule, and the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. I guess at this point, what we should do is take a voice vote by the board members to make sure that it meets all of these requirements that are set out on here. It's the regulatory flexibility analysis, methods of reducing impact of rules on small businesses. We would state that the overlap, duplicate, or conflict with other federal, state, and local governmental rules. I would state that that is a no in this case, and then I guess take a voice vote on each one.
That we agree?
Yeah.
Okay. I lost you there for a minute.
Mr. Chair, I'm sorry. I'm unclear of what we're doing. This is, can I get explanation?
I'm sorry?
Okay, all right. We have, more or less, we have to adopt this before we can go forward with the rulemaking process.
Of the rule changes?
Yes, yes. We have to adopt the Regulatory Flexibility Act before we can go forward.
I wasn't saying to do each individual one. I'm just saying as a whole, just go down each one and make sure that the new rules as a whole meet these requirements.
Do you want to read all of them? need.
Do you want to just do it at one time?
Yeah, just go over all of them, because we've done this before, and it's, as far as I know, it's the same thing that we've done before.
Number 2, that the rules have clarity, conciseness, and lack of ambiguity in the rule or rules. There's flexible compliance and or reporting requirements for small businesses. Friendly schedules or deadlines for compliance and or reporting requirements. The rules consolidate or simplify compliance or reporting requirements. Performance standards for small businesses, and there are no barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs.
And we have, we're meeting all of this, these rules that we have. That's our purpose in doing this, is to provide clarity and to make it abundantly clear to licensees what we expect. Friendly schedules, deadlines, there goes somebody that's about the 60 days, there's your 60 days, that's ample enough time. Performance standards, all of this, all this is covered. I don't see any negative impact whatsoever in anything. We are lowering fees, so
I think that,
I move that the proposed funeral board rules changes adopted meet the terms of the Regulatory Flexibility Act as described in the Tennessee Code.
okay. You will take. We have a motion by Ms. Sal. Do I have a second?
I agree with Ms. Sile and will second that.
I have a second by Mr. Highsmith. And so, Ms. Mosby, if you want to call her roll.
Wayne Hinkle.
Here. Yes, I'm sorry. I told you I'm a little asleep.
Tony Highsmith.
Yes.
Clark McKinney.
yes.
W.T. Patterson. Jane Gray Sowell.
Yes.
Robert Starkey.
Yes.
Anita Taylor.
Yes.
Thank you.
I would make a recommendation, you send number 2 to Congress and the House of Representatives and the Senate at your earliest convenience.
All right, and it's so we're looking for October. We got faith in you. You can get it done. All right, do I have a motion to adjourn?
Yes.
Have a motion by Mr. Patterson, second by Ms. Taylor to adjourn. All those in favor say aye.
Aye.
Opposed, motion carried. Thank you all for being here today.